In the last class, we had stopped with the shelf prospectus. I had given you information and explained you all about shelf prospectus. Shelf prospectus is also called as an information memorandum, and we had seen that it has all the material facts and it lasts for a period of 1 year, and company can give offers with the shelf prospectus for a period of 1 year. Now let us see the next prospectus type, which is the red herring prospectus. A red herring prospectus is a kind of incomplete prospectus as it does not include complete information, particulars of the quantity of securities offered for or the issue price of the securities being offered. It is usually issued at the time of IPO or for any issue done under the book building process. IPO, initial public offer, is when complete of a company offers its shares for the first time to the public. Book building process, it is a process by which company determines issue price of securities based on demand from the public. So red herring prospectus is a kind of incomplete prospectus, and it does not include complete information about the securities. Hence, it is called as a red herring prospectus. A red herring prospectus shall have the same obligations that are applicable to the prospectus. A company must file a red herring prospectus with ROC at least 3 days prior to the opening of the subscription list and the offer. So, red herring prospectus has the same obligations applicable as that of a prospectus, and a company has to file the red herring prospectus with ROC at least 3 days prior to the opening of the issue. So, this was about red herring prospectus. Now, next we shall be studying about offer letter. What do you mean by an offer letter? When a company undertakes further issue of shares by making the rights issue, that is offering shares directly to its existing shareholders in proportion to the shares held by them, the company issues a document called as letter of offer. It contains the details of the offer. So, what do you mean by letter of offer? Letter of offer is an offer letter which offers shares directly to the shareholders who are already the shareholders of the company. Means what? That when there is a rights issue, that is an issue takes place in which there is existing shareholders are given a right to issue shares. So that is called as rights issue. So when the people are here for the rights issue, they shall get a letter of offer, and it contains the details of the offer. So that is called as the letter of offer. Now next we shall be studying offer letter. An offer letter is issued to select a group of investors by a company when it comes to private placement. Placement offers offer of securities. Private placement means when a company is offering its shares to any select group of investors. Means what? Now what do you mean by offer letter? Offer letter means it is to a selected group of investors, and when company makes private placement offer of securities, then it means that the company is giving an offer to the only a selected group of investors or a selected group of people. Remember, there will be different kinds of share groups which will be held by the company. So this is called as a offer letter. Now next concept is contents of prospectus, which is cancelled for us due to the syllabus cancellation. So we don't have this. We don't have requirements in relation to prospectus penalty for non-compliance. Now the next one which we have is misstatements in a prospectus. So now what is misstatements in a prospectus? This is another important concept which you should go through. Remember, even if we have not gone through the above provisions, you should once go through it so that you'll understand what actually a prospectus means and how does it work. So, misstatements in a prospectus. As the investors make their decision to invest based on in the information given in the prospectus, care should be taken to ensure all information is accurate and no material fact is omitted. An untrue statement or a misstatement means the statement is misleading in form or content, or where any inclusion of a statement or its omission is likely to mislead the reader. So what do you mean by a misstatement? Misstatement means either it is in a misleading form or content, or it is likely to mislead the reader. Means what? That it is written with one meaning and the people understand it with the other meaning. If this happens, then there is a wrong impression of the company. Hence, it is very important to have a proper and accurate facts and no material factors omitted in case of prospectus. If an investor has bought shares of a company based on a prospectus which had misleading information or suppressed material information, then he can take action against the company. If there is any untrue or misstatements in the prospectus, the company and the persons responsible for issuing such prospectus will have to face following liability. So, if in case there is a misleading statement in the prospectus, in that case, the person who has been having that problem will have the right to take an action against the company. So who all are responsible for the liability? In that case, there will be civil liability or there will be criminal liability. Pay compensation for loss suffered by investor. Company or its officers will be fined or imprisoned or both. So, in case of civil liability, there will be only a compensation for the loss by the investors, and in case of criminal liability, it will be company or its officers will be fined or imprisoned or both. So this is about liability in case of misstatements, civil liability and criminal liability. Now next we shall see the distinction between memorandum of association and articles of association. So, memorandum of association, what do you mean? It is a document which defines and aims and objectives of the company. Then, articles of association, it is a document which contains the rules and regulations for internal management of the company. It is a primary document without which no company can be formed. It is the second important document prepared at the time of incorporation of the company. It is subordinate to memorandum. Scope. It lays down the area beyond which the activities of the company cannot go. It lays down the boundaries within which the articles will be framed. It provides the regulations within the boundaries laid down by the memorandum. It thus lays down the scope within which company can function. Next, we have contents, in which it lays down the range of activities of a company can do and cannot do. It contains the name of the company, state in which the registered office is located, capital structure, details of the object of company, liability of members, etc. It lays down rules and regulations for the internal management of the company. It contains details of allotment of securities, appointment duties and powers of directors, auditors, officers, winding up procedure, etc. So basically, we can understand that article of association and memorandum of association are interlinked with each other, also are dislinked with each other, because many of the things are dependent upon each other and some things are not dependent on each other. Relation, it defines relationship between company and outsiders. It defines relationship between company and members and between the members. Contradict, it cannot contain anything which contradicts the company's act or any other statute. It cannot contain any provision which contradicts the company's act as well as the memorandum. Alteration, the process of alteration of memorandum is little complicated, as approval of the central government may be needed needed at times. Altering the articles is a simple process, as often only a special resolution is needed to alter it. So basically, memorandum is a little difficult process and articles is comparatively a simple process. So with this, we complete the chapter of memorandum and articles of association. And in this, we have studied various aspects related to memorandum and articles. So you may solve the exercise. Now, after this, we shall be starting with members of a company. Next, chapter 5. What is members of a company? Who all shall be called as the members of the company? When is a person called as a member, and when is a person called as a shareholder? So, an institution or organization is formed for purposes like education, entertainment, sports, health, business, etc. It is a structured unit with well-defined objectives and relationship. The organization is formed and managed by persons, even though by itself it is a non-living setup. The person associated with an organization are termed as members. It can be rightly said that the organization is by members of members or and for members. Let's understand the concept of members, membership of joint stock company. Meaning of member. Now, what do you mean by member? Firstly, member means a person whose name is entered in the register of members of company and also includes holder of equity shares whose name is entered as beneficial owners in the records of deposit. Two prerequisites for a person to become a member of the company are the agreement in writing to take shares of a company, the registration of the person so agreeing in register of members of the company. So, member means a person who is entitled in the register of members of the company and include the holder of either equity shares whose name is entered as a beneficial owner in the depository. So, what are the main two requisites for a person to become member? First is agreement in writing to take the shares of the company. Second is registration of persons who are agreeing to in registering the register of members of the company. So now, what do you mean by register of members? The register will enlist all its members with their details in prescribed form. Depository, it is an institution where securities are held in electronic dematerialized form with National Securities Depository Limited and SDL Central Depository Services Limited. Beneficial owner is the investor who owns securities in electronic form and has interest in the securities. Now, next we shall be studying about shareholders without being a member. The transferee, buyer of shares or official receiver. In case of insolvency, legal heir. In case of death, as explained above, are shareholders but not members of the company. So now we shall be starting with eligibility of membership. Now, what is the eligibility for a person to become a member of a company? Let us know who can or cannot be a member of the company. Criteria. Buying shares amounts to making a contract. So any entity with person, organization competent to make contracts can be a member of the company. This topic therefore has a context to the provisions of the Contract Act 2. Subject to the provisions of Companies Act, memorandum and articles of the company, any person sui juris can become a member of the company as follows. So what do you mean by sui juris? Sui juris means who can manage his own affairs. So in this case, what do you mean? That criteria for buying shares is firstly any person who is competent, who is not abided or not banned by law can become a member of the company, who can read, understands the Companies Act, memorandum and articles of the company, who is sui juris means legally competent, who is not bankrupt or insolvent, or uh, who has not been omitted by law. So such person can become the members of the company. So now individual. In case of individual, who can be minor. A minor cannot be a member of the company himself. A guardian can enter into share purchase transaction on behalf of a minor. So, a minor can not become a member, but he can become in case his guardian has purchased share on behalf of a minor. Then, insolvent. Since the beneficial rights of shareholding are held by official receiver or assignee, so the insolvent person stops being the member. So, insolvent person means he has beneficial rights of shareholding and are held by official receiver. Then, insane or lunatic. Inability to enter into a contract renders to the persons ineligible for membership of a company. Then, foreigner. Since a foreigner can enter into contract, foreigner can buy shares to be member of an Indian company subject to provisions of FEMA 1999. FEMA means Foreign Exchange Management Act 1999. It aims at facilitating external trade and promote foreign exchange in the Indian market. So these people, these are individuals. Then next we shall be seeing for company, organizations. A company being a legal person can be a member of another company in its own name. It can become the member only if authorized by memorandum of association. Company cannot invest in its own shares. So a company cannot be a member of its own company, but it can be a member of the other company if it is mentioned in the memorandum of association. A proper separate clause has to be mentioned wherein it is written that the company can be a shareholder in another company. Then next we have cooperative society. Being a registered entity, it can be a member of the company. Limited liability partnership, since it is a juristic person, it can be member of the company. Hindu undivided family, the act does not prohibit membership of Hindu undivided family, but shares can be registered only in the name of its karta. So for limited liability person, it can be a member of the company. Then for HUF, it prohibits to other people, only the karta can become the member of the family. Then partnership firm. The firm cannot be a member of the company as it is not a registered entity, but firm can hold shares of a company in individual names of partners. So in a partnership firm, it can be individually held by different partners in their own names. Then next is registered trust can become a shareholder in company in its own name. So registered trust can be a member. So now here we'll see eligibility of membership of a company at a glance. So minor himself, he does not have eligibility. Then insolvent, he does not have. Insane lunatic, he does not have. Foreigner has eligibility. Karta or HUF, he has eligibility. Then company has eligibility. Cooperative society has eligibility. LLP has eligibility. HUF, Hindu undivided family, does not have. Partnership does not have. Trust has. So these are the entities which shall and which shall not have right to be the or shall not be eligible to be the members of the company. Now, different modes of acquisition of membership means what, that how can a company be a member. Let us now learn how one can become member of the company by subscribing to the memorandum. The subscribers to the memorandum of company are its members. That is seven in case of the public company, then two in case of private company, and one in case of one person company. In fact, they are the first members of the company. So, by subscribing to the memorandum, firstly, by subscribing to the memorandum, in case of public company, seven people can be, two in case of private company, and one in case of OPC can be the members. They are the first members of the company. Then, next we have by application and allotment of shares. Any person who wishes to buy company shares has to apply for the same, and on acceptance of application by the company, the person is allotted the shares and becomes shareholder, and thereby is the member on entering its members on entering his or her name in the register of members. So, by application and allotment of shares, whoever has applied to the company for shares and is allotted by the company, in that case he becomes the member of the company. Then his name once his name is entered in the register of members, he shall be a shareholder. Then by holding shares in dematerialized form, Any person who has shares in his name as the beneficial owner in the records of depository is the member of the company. Dematerialized form. It means financial securities in electronic form and not in physical or paper form. So, by holding shares in dematerialized form, shall be the member of the, even if a person is holding shares in the form of electronic form, he shall still be called as the member of the company. Then next we have by transfer. Any person who buys shares of a company if, from an existing member becomes its registered member after company accepts his transfer request. By transmission of shares. Transfer of shares by the operation of law in the events of death, insolvency and insanity of members is called transmission of shares. So what do you mean by transfer? Firstly, transfer means one person gives his membership or sells his shares, and he another person becomes the member of the share, the company. This is called by transfer. By transmission means either the person is dead, insolvent or insanity creates transmission, means from one person to another. The legal representative or heir in case of death, official receiver in case of insolvency, and administrator in case of insanity replace the concerned member. Next, nominee of a one person company. In case of OPC, the name of nominee whose name is given in the memorandum of OPC becomes its sole owner in the event of the death of the members. So, nominee of the OPC. In case the name whose in case of death, in case of OPC, the name whose the no, the nominee's name, which is given in the memorandum, becomes the sole owner in case of death of the main member. Then by acquiescence. Now, what do you mean by acquiescence? If a person is wrongly entered into the register of members or holds himself out as a member and knowingly allows his name to remain in the register of members without informing the company about the mistake and getting it rectified, is stopped from denying his membership and is liable to as a member, like in the event of winding up of the company, it is therefore called as membership or by principle of estoppel. Means what? Suppose a person's name is wrongly being entered into the register and he's getting all the benefits of the company, and even after knowing, the person did not inform the company. In that case, in case in future if the company goes into winding up, and in case there is some amount left from the person who was taking the profits, he shall also be liable for winding up event, whatever money is required by the company, so company can ask from that person also. So this is about membership of the company. Now next is about cessation or termination of membership. A person ceases to be the member of the company when any of the following occurs. Firstly, transfer of shares takes place. In the event of death or insolvency of a member, sale of shares by the member in the buyback offer by the company, forfeiture of shares by company, surrender of shares to the company by member, exercising of lien over the shares of a member by the company. So, what do you mean by cessation or termination of membership? Means end of membership, or membership is being cancelled by the company. First case is transfer of shares. Second case is in the event of death, insolvency of a member. Then sale of share by the member in the buyback offer or by the company. Forfeiture of shares by the company, surrender of shares by the company or by members, then exercising a lien over the shares of a member by the company. The person who holds redeemable preference shares ceases to be a member when the company redeems shares. So, what do you mean by redeemable preference shares? Redeemable preference shares means after a certain period of time, whatever time is specified in the certificate, share certificate, after that time, the person ceases to be the member of the company. Then next we have person refutes the contract of membership on the ground that he and she was cheated and frauded by misrepresentation of information given by company in the prospectus. So the person refutes or resigns to be the a member of the company. So he shall not be called as a member. And next, winding up of the company. In case there is winding up, no person shall be called as the member of the company. Buyback means a corporate action whereas a company buys back its shares from existing shareholders at price equal to or more than the market price. Forfeiture means cancellation of share by company if a member fails to pay money due on shares. Surrender of shares is a voluntary return of shares by member to the company. Lien on share means company does not transfer shares of a member till he pays his debt to the company. Redeemable preference shares are issued for a certain period of time and paid back at the end of it. So what do you mean by buyback? Buyback means company buys its own shares for the purpose of purpose of reducing the capital. Then forfeiture means cancellation of shares. In case there is forfeiture, in case the company cancels the shares, so there shall be no membership. Then surrender of shares, voluntary return to the member. Lien on shares means the company does not transfer shares to the member till he pays his debt to the company. Redeemable preference shares, which are redeemable and paid back at the end of it. So these are the various reasons where there can be cessation of a membership of the company. Now, in the next lecture, we will be starting with rights and duties and liabilities of a member.